Shelley has arrived. All right. We have not brought your, do you wish to go back and speak to him while we the other attorneys have not objected under the Rule 22. So we were going to go ahead and proceed with their clients in terms of some other housekeeping matters.
I have no objection to housekeeping matters, Your Honor, and I'll file my Rule 22 motion as quickly as possible. Is
Well,
Amelia here?
Yes.
Yes. Okay.
so would you like to go speak to him? Or we take up the other matters with the other defendants?
I would appreciate that.
All right, go ahead. All right, going on the record, going back to, we through communications last night with Ms. Fowler, my law, indicated that because he was representing his client, he is out of state. He was going to waive the first appearance hearing today. Therefore, we did not bring, I guess he's representing Mr. Hill.
Your Honor, Mr. Farnham is representing Stephen Blake Dickey, otherwise known as Di.
So we did not bring Mr. Dickey Di in today.
And Your Honor, I did speak to Mr. Farnham, and I told him that any representations I can make on his behalf, I would do as long as I was not in conflict. So if there's anything that needs to be addressed, that's just procedural.
I had Mr. Farnham put in writing his waiver. I thought that would be better. I didn't want to create any type of conflict between you representing or Mr. Farnham representing any of the defendants.
Thank you.
Right, thank you. Right, so initially, Mr. Fulcher, it's my understanding you had filed, the court had set this initially for a bond hearing today, as well as a preliminary hearing, as well as a first appearance. So now that we have new warrants, it's my understanding through that you and Ms. Sosby have spoken, and the court certainly believes that that bond hearing should be continued for purposes of judicial economy, because we have new warrants today which you would not be prepared to go forward on. So what I would suggest that we do before we leave today is set a new date for your motions.
And that's correct, Judge. We filed a motion for bond and a motion for a preliminary hearing on December the 12th. And we are agreeable to continuing both of those motions based upon these new warrants. And I want to emphasize continuing and not waiving the motion for a preliminary hearing. Yes, ma'am.
And Mr. Weehunt, on behalf of your client, I assume that are you going to be filing some of the same type motions, sir?
Judge, on December 11th, I've already filed a motion in request for a psychological and competency evaluation, a motion for bond, which we would like to get scheduled at the same time Mr. Fulcher has to schedule as well, if possible.
All right, so on the motion for competency, do you have an order? I'm assuming the state does not object. The court can sign an order.
I have spoken briefly over the phone with Mr. Wood on that. He indicated the office before he could consent to anything, so I don't have anything prepared, but I can certainly get you on an order.
Ms. Sosby.
We have no objection to a psychological evaluation on behalf of the defendant. Hill, and if Mr. Weehunt would like to come to the district attorney's office following court today with a draft copy of the order that he could utilize.
All right. And for purposes of the record, why don't we go ahead and introduce themselves on the record so that we'll know who's speaking.
Yes. I'm Allison Sosby, district attorney representing the state of Georgia.
Yes, Your Honor. Frank Wood, Assistant District Attorney representing the state of Georgia.
Judge Charlotte Fulcher, representing Lakota Cloer.
Andrew Weehunt representing Dalton Manuel.
As to the first appearance, now that both of the defendants present have attorneys, some of the advice I'd be given to them, is I'm sure you've already given to them. So what I would like to do initially is go back through as to each of the defendants and read the additional warrants that's been issued. Some of these, in reading these, may have already been charged, but it appears that these more clearly outline what they are charged with. Ms. Chastain will be giving these numbers, and she may not have finished yet.
Give me just about
Okay. Starting with State of Georgia versus Lakota Cloer did, and this is warrant number 2019 SCW1, charging Mr. Cloer with malice murder in said county between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018. The place of the occurrence of said offense being 135 Elrod Lane, Morganton, Georgia 30560. And against the laws of the state of Georgia, said offense being described as follows. While located at the above address between 12 a.m. and 1 a.m., said accused Lakota Cloer, C-L-O-E-R, individually and as a party to the crime, did commit the offense of malice murder when said accused unlawfully with malice aforethought caused the death of Justin McKinney, a human being. As to warrant number 2019 SCW2, charging him with the offense of felony murder. Again, the place of the occurrence of said offense being 135 Elrod Lane, Morganton, Georgia, and against the laws of the state of Georgia, said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused Lakota Cloer individually and as a party to the crime did commit the offense of felony murder when during the commission of a felony offense, to wit, aggravated assault, as charged in Official Code of Georgia annotated 16-5-21, he caused the death of Justin McKinney, another human being, in respective of malice. The next warrant is 2019 SCW3, charged with the offense of aggravated assault. that in the said county between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018, the place of the occurrence of said offense being 135 Elrod Lane, Morganton, Georgia, 30560, and against the laws of the state of Georgia, said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused, Lakota Cloer, individually and as a party to the crime, did commit the offense of aggravated assault when said accused assaulted Anna Franklin with a deadly weapon. As to warrant number 2019 SCW4, again, involving the defendant Lakota Cloer, did between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018, the place of occurrence of said offense being 135 Elrod Lane, Morganton, Georgia, 30560, and against the laws of the state of Georgia, said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused Lakota Cloer, individually and as a party to the crime, did commit the offense of aggravated battery when said accused maliciously caused bodily harm to another, to wit, Anna Franklin, by rendering a member of her body, her left arm, useless. Those are the four warrants as to Mr. Cloer. Ms. Sosby, as to the alleged victims in this case, has the family members of Mr. McKinney been notified, and are they present?
Yes, Your Honor, they have been notified. We have Ms. Catherine Greenway, who is Mr. McKinney's sister. She is here and present with us in the courtroom today. I would like to make a notification to the court that she did have a prior internship with drug court approximately 9 years ago and was involved in CASA 13 years ago, but I just wanted to make that known. We also have Anna Franklin, who is our other named victim in the warrants. She was notified of the proceedings. She is not present today and did decline to appear.
As to the defendant Dalton Manuel, get those in order. Mr. Rehan, it appears that the exact same charges that I just read in reference to Mr. Cloer are the same charges that your client has been accused of, and you wish for the court to reread those warrants, sir.
Judge, we can waive formal reading if the court could just give me the warrant number, please.
I will do that. As to Mr. Manuel, as to Mr. Manuel, the malice murder would be 2019 SCW 13, 2019 SCW 14 as to felony murder, 2019 SCW 15 as to aggravated assault, 2019 SCW 16 as to aggravated battery.
Thank you.
And we will make sure that you have, each of you have copies of these warrants as well. In reference to this, one of the purposes of the first appearance, of course, is to allow the defendants to know what they are being charged with. Some of these charges are some of the same charges that they were brought in last time for the first appearance. Some of the language has been changed. One of the first things that we do is certainly acknowledge, let them know of the charges which they are accused. The next thing, of course, is their right to have an attorney to represent them, and if they cannot afford an attorney, the public defender's office can provide an attorney if they meet the financial qualifications. It appears at this time that both of the defendants in the courtroom at this time have attorneys. In reference to that, the other thing that we advise them is that they would have the right to have a bond hearing and a commitment hearing or preliminary hearing. It appears that both of you have filed those motions, and what the court would intend to do would be to set those down on the same day, Ms. Sosby, unless you know of any reason why that should not occur.
No, I do not.
And maybe before we can leave today, that we can set a date and time to have that done. In addition, they would have the right to have a grand jury indictment in this case. I am not sure of the date the grand jury will meet again in Fannin County or when the case will be ready to be presented to a grand jury, but certainly this is felonies and they would have the right to have that given to a grand jury. Ms. Sosby, do you know, I don't have my calendar in front of me, when the next grand jury will be meeting here in Fannin County now?
February 18, 2019 is when the grand jury will reconvene.
Do you know at this point in time if the investigation will be completed? Is it your plans to present this to the grand jury at that time, or do you know yet now?
I could not speak with certainty, although it would certainly be expeditious if we were able to meet the February 18th date.
Certainly, both defendants are presumed to be innocent until such time that they are found guilty beyond a reasonable doubt. In addition, they are entitled, if they want to speak to law enforcement, they certainly have the right not to speak to law enforcement, but could not speak to law enforcement unless certainly their attorney was present. Any other rights that you would like for the court to advise your clients? Certainly they have the right to remain silent. They are not required to make any type of statement or to provide any evidence. That would be the responsibility of the state. In presenting this case to a grand jury as far as probable cause for the indictment, and later on, if they are in fact indicted, the state of Georgia would have the responsibility of providing evidence to presume that, to prove that they are guilty beyond a reasonable doubt. Any other rights, Mr. Folger, that you'd like the court to give your client?
No, Your Honor.
Or Mr. Weedham?
No, Your Honor.
Certainly when defendants already have an attorney at the first appearance, I know that you've already talked to your clients about this information, but the court is also obligated to re-emphasize some of the most important rights. All right, so anything further in reference to Mr. Cloer or to Mr. Manuel, other than maybe trying to set a court date for the bail bond hearing as well as the preliminary hearing?
Nothing from the state, Your Honor.
If y'all could look at each other's calendar and present some dates that everyone be available, let the court look at my calendar. January is a little bit different than usual. We don't have court as often because of some of the judicial seminar. Certainly we can make arrangements to try to do that, possibly even next week if everyone thinks they would be ready at that time. It appears that GBI Special Agent Jamie Abercrombie is the lead agent in this case. Is that correct?
She is, Your Honor. And as to next week, that is criminal trial week in Pickens County. And depending on how the calendar goes, maybe tied up in Pickens County next week, Your Honor.
Let me see if I can check.
I do have a master calendar if the board would like to review it.
Pulling it. Approximately how long do you think, certainly not limiting any of you to the amount of time, but approximate amount of time that would be required for the motions?
Judge, I don't anticipate a bond hearing lasting long, maybe an hour preliminary hearing, I can't really speak of until we're underway.
Mrs. Osby, do you have any estimate as to time?
Your Honor, I think that between bond hearings and preliminary hearings, that we could handle all of that within half a day.
Ms. Osby, and Mr. Folks, Mr. Rehunt, Friday, January the 18th. That's the Friday of the trial week, Ms. Osby, in Pickens, but,
Judge, I'm good to go with that.
I have nothing scheduled, so I can do that.
would that be a possibility of a date?
Your Honor, Mr. Wood has informed me that I believe that the case that will be going out in Pickens County will be Mr. Jordan. I was anticipating potentially being on another case, so Friday of next week would, Friday the 18th would work.
Mr., because I was looking at the jail list, preparing that today for Pickens County, Western Jordan, so I think I did list that as number one jail list. Even though it's Judge Priest's week, I usually do the jail list.
Wyman was the case that I was anticipating being on, and that was continued from that leave.
Yeah, the attorney's mother's here. All right, so January the 18th appears to be okay for everyone?
Yes, ma'am.
Yes, ma'am.
Because of the transportation issues, if we set it at 10 o'clock, would you be able to get everyone here by 10? All right, so let's set that for January the 18th at 10 a.m. Any other matters that we would need to take up with these, with Mr. Cloer or Mr. Manuel?
Not today.
They could be taken back. Yes. Need an opportunity to start.
We spoke earlier before the commitment over here.
I do, Judge.
All right. Father, here, if we can let Mr. Fulcher speak with his client, we has indicated he does not need any additional time.
That's correct.
As to,
Judge, can
Yes, ma'am.
all right, as to the new warrants that were taken, again, some of these warrants are for some of the same things they had been charged with before, but the writing is different to make it more specific as to what they were actually accused of. So, in reference to the state of Georgia versus Hunter and Nicholas 19 SCW 9, malice murder, in that between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018, the place of occurrence of said offense being 135 Elrod Lane, Morganton, Georgia 30560, and against the laws of the state of Georgia, said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused Hunter Nicholas Hill individually and as a party to the crime did commit the offense of malice murder when said accused unlawfully and with malice aforethought caused the death of Justin McKinney, a human being. Okay, warrant number 2019 SCW 10, felony murder. That between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018, the place of the occurrence of said offense being 135 Elrod Lane, Morganton, Georgia, 30560, and against the laws of the state of Georgia. Said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused Hunter Nicholas Hill, individually and as a party to the crime, did commit the offense of felony murder when during the commission of a felony offense, to wit, aggravated assault, as described in Official Code of Georgia Annotated 16-5-21, he caused the death of Justin McKinney, another human being, irrespective of malice. Warrant number 2019 SCW 11, aggravated assault. Again, that between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018, the place of occurrence of said offense being 135 Elrod Lane, Morganton, Georgia, 30560, and against the laws of the state of Georgia, said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused, Hunter Nicholas Hill, individually and as a party to the crime, did commit the offense of aggravated assault when said accused assaulted Anna Franklin with a deadly weapon. As to warrant number 2019 SCW 12, aggravated battery. Again, between the hours of 12 a.m. and 1 a.m. on the 4th day of December 2018, the place of the occurrence of said offense being 135 Elrod Lane, Morganton, Georgia, 30560, and against the laws of the state of Georgia, said offense being described as, while located at the above address between 12 a.m. and 1 a.m., said accused Hunter Nicholas Hill, individually and as a party to the crime, did commit the offense of aggravated battery, when said accused maliciously caused bodily harm to another, to wit, Anna Franklin, by rendering a member of her body, her left arm, useless. You may be seated. Thank you.
Thank you, Your Honor.
And Ms. Sosby has already put on the record that the family of the alleged victim, Justin McKinney, had been notified. We do have family members here today, and that the alleged victim, Anna Franklin, was notified and elected not to be here today. Is that correct?
That is correct, Your Honor.
All right. Because Mr. Hill, there's some things I will go over, understanding that at this point in time, Mr. Hill does have an attorney, and therefore most of what I will be saying today, you probably already discussed with his attorney. First of all, Mr. Hill, you have the right to have an attorney to represent you. You are now represented by Ms. Shelley. You understand that? You have the right to remain silent. That means that no one can require you to testify either for or against yourself, or to make any statement, and any further questioning about this case must be in the presence of your attorney. You also would have the right to have these cases presented to a grand jury here in Fannin County, who would vote to find probable cause, or who would need to vote to find probable cause to indict you. And if you're indicted, later on you would have the right to a jury trial here in this county as well. And the state of Georgia would have the responsibility of presenting evidence to a jury to prove that you're guilty beyond a reasonable doubt. You will also have the right to have a bond hearing and or a commitment hearing on this matter. Ms. Shelley, what had initially taken place, Ms. Sosby, Mr. Coulter, and Mr. Wehunt indicated that January the 18th at 10 o'clock a.m., it appeared that everyone's calendar was clear. The court checked her calendar, and it appears that I'm available on that day as well. If you could check your calendar to see if you would, I'm assuming you're going to file the same motions, so we could have those heard at the same time.
That would be appropriate, Your Honor. I believe I've got juvenile court on the 17th. Is the 18th a Friday?
Yes, ma'am.
Okay, yes. I'll be available.
Wait, I'm sorry, she said it's the 17th Friday? Is that
18th.
The 18th is Friday, so I've got juvenile court on the 17th.
Oh, okay.
Yeah.
Ms. Shelley, is there any other advice that you would like me to give your client at this point in time now?
No, Your Honor.
Any other matters to be taken up by this court?
Not from the state, Your Honor.
Michelle, do you need, if so, I'll allow it. If not, then I will direct the deputies to take them back to the detention center.
He understands the proceeding, he's where we are.
This concludes the hearing. Thank you very much.
Thank you.
I guess to the state, and do you have a copy of the warrant now?
I do have a copy of the warrants, but I was going to make another copy for his parents if Ms. Chastain.
I am turning the original warrants over to Ms. Chastain.
Okay.
So if anyone needs any additional copies, as well as the Rule 22 order that I had signed.
Thank you, Your Honor.